Okay, I'm going to get started just with the welcome and before we hand over to David as we let everyone in. Good morning on this snowy morning again. My name is Lisa Carlson. I'm the Chief Exec of Canterbury's Business Improvement District, and I'm hosting the session today with my colleague Rachel Pillard, who is our Marketing and Communications Manager. And a very warm welcome back to David Morgan from Girlings Solicitors. David, I think this is your third session that you've done with us. So today's session is on HR and employment law and what to expect in 2021. And obviously there's a lot to discuss as far as that goes. We are delighted to welcome you all this morning. We've run, I think, Rachel, it's 17, maybe this is our 18th online session since, since March. We've done a number of training sessions, but also in conversation sector webinars and more informal meetings just to ensure we stay connected with you and so we can all stay connected in whatever way is possible during these times. So delighted to have David this morning. If you've missed any of our training sessions, they are recorded and on YouTube. So you can go to our website and I'll put the link in the chat and look those up. There are lots of recordings and slides with tips, top tips, particularly on social media and marketing, but lots of other sessions as well. And speaking of, our next session is on the 10th of March with Zoe from ZC Media, who'll be looking at making the most of Facebook business. So we hopefully look forward to seeing you or welcome you again then. I also just wanted to mention two things. We are running a marketing campaign now called #IPledge. And every week we're featuring a different sector. So we started with our beloved pubs. We then featured some of our beauty businesses, and we're now this week featuring entertainment, and we've got an interview with the Marlowe. So every week we interview one business, but we feature and try and interact on social media with as many businesses as possible in that sector. And the idea is for all of us just to remember our businesses fondly, keep them front of mind, go onto Facebook, pledge whichever businesses you're going to go visit as soon as it's safe to do so, tag in a friend. And what we want to do is keep that conversation going on social media so we can let our businesses know that we're thinking of you and that we really look forward to visiting you again as soon as it's possible to do so. So that's #IPledge on Facebook and on Instagram. And the other thing I want to mention is grants. Hopefully all of you who have applied for grants will have had everything caught up through to the 15th of February as of last week. For the vast majority of people, that's what Canterbury City Council have told us has happened. If that's not the case, we'd really love to hear from you so we can help. And we can also talk to you about whether you might be eligible for the discretionary grants. So that's it for me for now. As always on these sessions, if you have a question, a comment, anything you want to put in the chat, please do so. And when it comes to question time, we'll be monitoring the chat, but go ahead and put your comments and questions in as we go so we can monitor that and be ready to ask your questions. So again, David, thank you for joining us, and over to you.
Thank you. Okay, so I'm going to look at this morning at about what to expect in 2021, and we'll have a brief look over furlough. And because a lot of what I expect to see in 2021 will unfortunately be redundancies, I'm going to briefly take you through what you need to do to fairly dismiss someone by reason of redundancy as well. So if we can move on to the next slide. So we'll look at what will change in 2021, what new laws are coming in. Because of firstly Brexit and then COVID, there has been very little change in employment law. So this is going to be a reasonably brief section. We'll then look at the extensions to the furlough scheme and what's happened since November with regard to furlough. And then we'll move on to looking at redundancy procedures. And then there will be some time at the end for questions and answers and any other queries that you have. So what we know will change in 2021, because obviously government has not been communicating in the way it would normally communicate with us about changes to employment law. We know that there have been changes to immigration rules, and that was effective from the 1st of December 2020. So we have moved from the old system of tier 2 and tier 1 immigration rules, and we now have a skilled workers regime. It's not the major change it's been billed at as part of Brexit, that the rules are still a points-based system, and so it doesn't look enormously different from the old rules, but obviously there have been some changes there. And there's also changes to the status of EEA workers after the 30th of June 2021. So if you have any EEA workers engaged in your business who haven't already gained the right to remain in the UK after the 30th of June, that does need to be taken care of before that date. Moving on to tax, as far as we're aware at the moment, there will be changes to the IR35 off-payroll regime from the 6th of April. Now, the IR35 regime basically deals with who assesses what tax should be paid for self-employed consultant workers, and whether that is in fact disguised employment on which PAYE should be paid. It's not an issue for most employers who don't use consultants, but it would be an issue for those who perhaps do use consultants and where consultants are employed through their own company. Now, this was postponed from 6th of April 2020 because of COVID. It's possible that it will be postponed again this year because obviously we remain in lockdown and businesses may not be ready for this change. Okay, if we can move on. We know that there will be changes to national minimum wage with effect from the 6th of April. They are rising again, and they aren't rising by quite as much this year. Traditionally, we've seen increases in national minimum wage of around about 5% from year to year. They are down to into the region of about 2% this year, and I believe that's because the government recognised that employers are in a difficult place at the moment and don't want to put too much pressure on them. One change that you will need to be aware of is that the top rate of national minimum wage, which previously applied from age 25, will apply from age 23 from the 6th of April. So you will need to review your payroll and make sure that if you had any automated systems in place that granted people a pay rise from their 25th birthday, that now needs to be amended to take into account that it's 23 years and over now that receives the top rate. If we can move on. Sorry, thank you, Rachel. So for changes we don't know about, which may come in later this year. These are all changes that were proposed in the Queen's speech way back in December 2019, just after Boris won that election. And a whole raft of potential employment law changes were proposed in the Queen's speech, none of which have progressed any further because of COVID. And I really wouldn't expect these to progress any further this year, if I'm completely honest, because I think we're going to be dealing with, if not COVID itself, then the recovery from COVID. But things that we can look forward to at some point in the future are the discussions in Parliament about whether flexible working would be the default position. So employees would gain the right to flexible working rather than the right to request flexible working. There are proposed changes to the restrictive covenants regime. Now, restrictive covenants are clauses in an employee's contract, which, for example, would prevent them going to work for a competitor for 3 months after the termination of their employment. They're very common, for example, in hairdressers, where hairdressers would usually be prevented to go to work for a salon down the road because hairdressers tend to take their clients with them and away from the business they were working for. There are proposed changes to that because there is concerns that they are being overused against lower paid employees, and perhaps it would, one of the proposals is that if you're going to restrict someone from post-employment activities, perhaps you should pay them for the period of the restriction. There are going to be proposed changes to breaks in continuity of employment. So at the moment, if you ceased work for your employer on day one, but were then taken back on a new contract on day 5, your continuity of employment would be preserved, because if you resume employment within one week or in the same week that you left, then your continuity of employment is preserved. And there is a proposed change that that period will be extended to 4 weeks. So if your contract is terminated and then renewed within 4 weeks, you would maintain your continuity of employment. And there are also discussions to be had about increased protection from redundancy during pregnancy and maternity, and changing the laws around that to give pregnant mothers and new mothers more protection from being made redundant during that period. Now, like I said, all of these have been delayed because of COVID-19, and I'm really not sure that we will see these dealt with by Parliament anytime soon, but they are in the background. With regard to employment tribunals, because of COVID, before people can bring a claim in the employment tribunal, they must engage in early conciliation with the ACAS, which means they must notify ACAS that there's a potential claim, and ACAS will then try and conciliate a settlement between the employee and the employer. Now, this is a compulsory procedure in that people have to contact ACAS. It's not compulsory in that people have to go through with conciliation if they don't want to. However, the period of which you must putatively engage in conciliation if the parties are amenable has automatically been extended from 4 to 6 weeks during the COVID period as a response to things generally taking longer and people working from home. If we could skip back, please, Rachel, thank you. And just to make you aware, there is an enormous backlog of claims in the employment tribunals. Over 40,000 claims are awaiting hearing, and there is a similar position in the courts at the moment. This isn't solely due to COVID. There were already very, very long waiting lists before COVID took place, but COVID really hasn't helped this situation. And if a client is coming to me at the moment, I'm now estimating that they won't get their claim heard this year, and it will be in next year. And if it's a very complex case where the hearings may be 3, 4, 5 days long, we're probably perhaps even looking into the late half of 2022 and into 2023. Changes to the tribunal rules have been made by Parliament to enable judges to deal with matters more speedily and more easily, and changes have been made to enable remote hearings. And the Employment Tribunal is actually one of the jurisdictions that has embraced remote hearings quite well, and so most hearings are taking place online at the moment. Okay, if we can move forward. Okay, looking at the furlough scheme. So the last time I did a presentation to Canterbury Bid, we were in mid-March or late March. The furlough scheme had just been introduced. Lockdown had just come in, and we were all hopeful that the furlough scheme would last for 3 months and lockdown would last for the 2 to 3 weeks that was promised, and we would all be back to normal by the summer. And here we are 12 weeks later, and the furlough scheme is still in place. And currently it's deemed to end on the 30th of April after it was extended by Rishi Sunak in the first week of November. We don't yet know if there will be a further extension. I wouldn't be surprised if there was. If lockdown isn't released in April, then I think almost certainly the government will extend it. If lockdown is released sometime before the end of April, then perhaps not. But I think there is going to have to be some help for businesses beyond the 30th of April if lockdown is still in place, even if it's partially in place just in the hospitality sector at that time. I would hope this time, the last time furlough was extended, it came to an end on the 31st of October, and it wasn't extended then until towards the end of the first week of November. This actually led to a lot of people getting made redundant in October in anticipation of the end of the furlough scheme. And perhaps some jobs were lost that could have been saved had the scheme extended further. So I would hope that the government have learnt their lesson from that, and that if we are going to have an extension, it will be communicated fairly early. The current position with furlough is that the furlough rules have changed 4 or 5 times since their first inception last March. My apologies, I'm just having some problems with my screen. I'll be back with you now. And there were all sorts of rules and regulations changed about who was eligible for furlough, when they had to be on payroll. The current position is that you can furlough an employee for an employer, provided the employers had an online PAYE enrolment prior to the 30th of October in a UK bank account. So they must have had an online payroll system in place before the 30th of October. And employees who are to be furloughed must have been on that payroll prior to the 30th of October. They don't have to have been furloughed before, which was one of the rules that were in place up until the 30th of October, but they must have been on the payroll prior to the 30th of October. Furlough must be agreed in writing with employees, and there are a number of precedent furlough letters out there. Whilst you don't have to have the employee's written agreement to furlough, a letter must have been sent to them outlining the terms of furlough, and you must keep written records of the terms of that agreement for 5 years, and you also must keep records of the hours that furloughed employees are working or not working, also for a period of 5 years. Furlough can currently be full or flexible, so employees can be fully furloughed and receive 80% of their usual pay from the government, or they can be on flexible furlough, which means that they can work part-time, they can work on pretty much any working pattern, and the employer can claim furlough pay for the hours that are unworked. Obviously, that working pattern needs to be recorded, and it needs to be agreed with the employee, and that needs to be recorded in writing. The current position is that holiday should be paid at 100% of the usual rate. If we could just skip back, please, Rachel. Now, with regard to the rate that the employee would get normally, that's very much a matter for, as it always has been, it's a matter for agreement between the employer and the employee. You can't force an employee to take 80% of their usual pay. It's a contractual change that has to be negotiated. But my experience is that most employees have agreed to take the amount of pay that the government will claim. A change to the system that has come in since the extension of the furlough scheme in November is that you can no longer claim furlough in a notice period. So once you give notice to an employee that their employment is terminating, you can no longer reclaim that pay from HMRC. And another change that has taken place is that from the 1st of January, employers who are claiming from the furlough system, their names have now been published by the government in order to deter false claims. And indeed, one of the motivations for publishing names is so that employees who perhaps have been working can see if their employer is claiming furlough for them, even though they haven't actually been put on furlough. There are some anecdotal reports coming through that this is happening, that some unscrupulous employers are claiming furlough for employees who in fact haven't been furloughed at all. And it is hoped that making employers' names public by publishing a list of employers who are claiming furlough will allow employees to alert the government if they feel that the employer is acting unscrupulously. So with regard to furlough and notice and redundancy, like I said, before the end of the last furlough period, we had a very busy period of redundancies, because prior to the extension of the furlough period in November, employers could claim furlough pay for notice periods. So they could give notice to an employee, say at the beginning of November, and claim furlough, say at the beginning of October before the end of the old scheme, and claim for that notice pay, or claim for 80% of that notice pay. So this position has now changed, and furlough can't be claimed for an employee who has been given notice, but employers are still going to need to plan ahead. You don't need to plan ahead in view of perhaps utilising the furlough scheme to pay out for the notice period, but obviously the furlough period, as we understand it, will come to an end at the end of April unless we hear differently. You may have employees who've got 12-week notice periods, anything up to 12 weeks, depending on their length of service. And you are going to have to start thinking ahead, perhaps if you are going to need to make redundancies, about when you are going to commence a redundancy period and give them notice, because it may be, obviously the incentive to do that sooner rather than later is gone, because you can no longer claim notice pay, but you're still perhaps going to have them longer on their books if you don't start consultation sooner rather than later. Okay, so moving on to redundancies and redundancy procedures. Unfortunately, we have seen an awful lot of redundancies over the last 6 months. We've already seen huge numbers of redundancies. The unemployment rates have skyrocketed during the first year of the pandemic. And the latest news at the time I wrote this presentation towards the end of last week was that we're expecting a further 4% fall in GDP because of this lockdown. And this fall is going to perhaps coincide with the end of the furlough scheme if it's not extended. There are already calls for a further extension of the scheme, but I think even if furlough is extended, this perhaps is just delaying the inevitable for a lot of businesses. And it is inevitable at some point that businesses will need to make redundancies either sooner or later this year. So in order to perhaps prepare businesses for that possibility, I'm going to very briefly go through a redundancy procedure and what businesses need to do to effect fair redundancies. So a redundancy situation occurs in law either where the employer has ceased or intends to cease continuing the business. So in cases where there's a complete closure of the business, or where there's a reduced requirement for employees, where the requirement for employees to perform work of a specific type or conduct that work at the location in which they're employed has ceased or diminished. So there's a reduced need or no longer a need for employees to perform the work they do at the place they do it. Those are the two legal definitions of a redundancy situation. Rachel, have we skipped forward a slide there? Thank you. The fact that a redundancy situation legally exists will not on its own allow employers simply to dismiss people without following any procedure. There is still a burden on an employer once the redundancy situation has been established. The employer still has to show that it acted reasonably in treating the redundancy as a sufficient reason for dismissal, which means that a fair procedure must be followed. So in order to show that the redundancy situation at a particular place has led to a fair redundancy, employers, before they consider going to the next stage, they must consider ways of perhaps avoiding the redundancy situation altogether. So could a compulsory redundancy of an employee be avoided by way of offering voluntary redundancies to a group of employees or offering employees early retirement? Could redundancies be avoided by reducing the number of agency workers or contractors employed in the business? And could an overtime ban or a recruitment ban and relying on national wastage provide a potential solution? Now, in many situations, particularly with small businesses, these just simply aren't going to work for the employer because perhaps there will be very few staff and perhaps there will be no money there to incentivize a voluntary redundancy or an early retirement. But the employer does need to think about these and perhaps tick those boxes just to show it has considered them before it moves on to the next stage. Another thing to consider, especially for larger businesses, is that where an employer proposes to make 20 or more employees redundant within a 90-day period, then a statutory procedure applies. So under the Trade Unions and Labour Relations Consolidation Act, a statutory consultation procedure is in place. And employers, where they're planning to make 20 or more employees redundant, must elect and consult with representatives of the affected employees. So they must facilitate a group of employees to elect representatives, and then they must consult with those representatives rather than the employees directly. And the consultation must begin at least 30 days before the dismissals are effected. And where you're proposing to make 20 or more employees redundant in a 90-day period, you must also notify the Secretary of State that you're doing so. And there's a form HR1, and it's actually a criminal offence not to inform the Secretary of State in those circumstances. Where there are less than 20 affected employees, that statutory consultation procedure doesn't apply, and indeed there isn't a legally defined redundancy procedure that you have to follow. But you do still need to consult with affected employees. There is case law that indicates a redundancy will be unfair unless you consult with employees, and you must follow a fair procedure for the tribunal to regard the dismissal is unfair. Over the years, the tribunal case law has set out the things that they say should be done in order to effect a fair redundancy. And we are relying on employment tribunal case law in small redundancy situations rather than any statutory provisions. An employer should take care not to conclude the role is redundant until they've completed a fair procedure. Now, this is a mistake that's been made by that is made quite frequently by employers who will call an employee into the meeting and tell them their role is redundant before an employee has been through a consultation. The employer may well intend to consult, but it gives the impression it's already come to a conclusion that the role is redundant. So do take care with the language used if you are commencing a redundancy procedure, because until the conclusion of the consultation with the employee, the role is at risk of redundancy and should not be termed as redundant, because of course you don't know what the consultation process will result in. It might result in a change of mind for the employer, depending on what the employee comes up with during the consultation process. So remember to use the phrase at risk of redundancy until the consultation process is over. So what does a fair procedure look like? So in order to follow a fair redundancy procedure, employers generally you must inform and consult with the affected employees about the reasons for the redundancy. You must select employees for a redundancy fairly. So if you've got a group of 5 employees, but you only need 3 of them going forward, you must select the 2 that are to be made redundant fairly. You can't just arbitrarily go in and pick out your 2 least favourite employees and select them for redundancy. You must consider alternatives to dismissal, such as whether alternative roles are available. So if perhaps you are working in a business where perhaps there are 2 branches, you have premises perhaps in another town, you would need to consider, are there alternative roles available either within the same branch or at a different branch, and consider, even if those roles aren't the same type of work done by the employee, provided they're broadly equivalent, they could be offered to the employee as an alternative to dismissal. And the employer has really to do all it reasonably can to avoid the redundancy. There is a thread running through the case law that if you can avoid the redundancy and it's reasonable to do so, then you should. And that duty to avoid the redundancy and look for alternative work, it runs all the way up to the time of dismissal. It doesn't stop at the time that you declare a role redundant and inform the employee of that, but it continues throughout the notice period. So if the situation changed or a role became available during the redundancy period perhaps because another employee has resigned their employment during that time, then your duty to consider that suitable alternative role for the redundant employee, it continues even after you've given them notice. They don't have to accept that role once notice has been given, but if an employee doesn't agree to reverse the notice and take the alternative role, there is a risk that that employee also gives up the right to receive a statutory redundancy payment. So the refusal of a suitable alternative role can remove that employee's right to a statutory redundancy payment. So the first step in the process, once a redundancy situation has arisen, is that you need to inform the employees that situation has arisen. They must be informed that their role is at risk of redundancy. An employer should inform them of the reasons for the risk of redundancy, which might be a downturn in business or a decision of the business to close a particular branch because it's no longer profitable. You should inform them of the number of other employees affected by the redundancy and the likely timescale in which it's likely to take effect. Now, if employees are to be placed in a pool of at-risk employees, so this is the situation, like I said, where perhaps you need to reduce a group of 5 workers to 3, they need to be informed of the number of employees in that pool and how many of the roles will be selected for redundancy. And usually the way this is done is that it's done in a face-to-face meeting, and then the information that's communicated in that meeting is confirmed in a subsequent at-risk letter. Now, generally, employees have the right to be accompanied in a redundancy meeting, but that doesn't apply to that first at-risk meeting, only to subsequent consultation meetings. Once the employees have been informed of the situations in the letter, they should then be invited to a consultation meeting. They have the right to be accompanied at the consultation meeting by a colleague or trade union representative, and they must be given reasonable notice of the meeting. So I would usually invite employees to the first meeting actually in the at-risk letter. I would combine those 2 letters to set out the information informing them of why their role is at risk of redundancy, and also invite them to a consultation meeting to discuss those facts. And I would always give around about a week's notice of a consultation meeting. Now, with regard to consulting employees in times of COVID, yes, you can consult with furloughed employees. They are not, consultation about redundancy is not regarded as performing services for the employer, and so you can consult with employees about a redundancy while they are furloughed. And what most employers are doing at the moment is doing consultations by Zoom or by telephone, if you can't arrange a socially distanced face-to-face meeting. And indeed, in the current lockdown, perhaps that would be the best way of going about it. But of course, if you can socially distance, then you should, but do be aware that you will potentially have 4 people in the meeting. You will have the person conducting the meeting, you will have a person perhaps taking minutes of the meeting, you will have the employee, and you will have their companion. And so social distancing can become a little bit of a problem when you've got 4 people perhaps sitting in the same room. With regard to what you consult the employees about in that meeting, you need to consult with them about potential ways of avoiding the redundancy, and don't be too presumptive here, because it has been known in the past for a group of employees to get together, for example, where perhaps 5 employees are in a pool for redundancy, and 4 of the and 4 will be kept and 1 will be made redundant. It has been known for employees to get together and suggest that rather than make one of their colleagues redundant, perhaps they could all accept a pay cut to give the employer the saving it wants. So don't be too presumptive about potential ways of avoiding the redundancy. Employees can come up with their own ways of avoiding it themselves, and you need to be open and to consider those suggestions fully. You should consult them about the pooling of employees. So you should perhaps discuss why they've been placed in a particular pool. And sometimes pooling can be a divisive issue, because employees perhaps should think they should be pooled with other employees if the jobs are fairly similar. And so you might say, for example, we're not pooling you because we think yours is a unique role in the business. The employee will come back and say, well, no, actually my role is fairly similar to my colleague, and you should pool me with him, and only one of us should be made redundant out of that pool. So do consult over pooling, do listen to what the employee's got to say. You don't, it's a consultation process. It's not for the employee to dictate to the employer about what they should be doing, but you do have to listen to what they've got to say. And you do need to consult with them about the criteria for selection within the pool. Now, the days of last in, first out are gone as a selection criteria. And indeed, last in, first out could be indirect age discrimination, because it is likely that younger employees are more likely than older employees to have been the last in to that role, and therefore are selected on the first out basis. So that automatic old-fashioned criteria of last in, first out as a selection basis for selecting for redundancy, you will need to think twice about using that. But you do need to develop a sort of scoring criteria That can be based on performance criteria, it can be based on attendance, and any number of factors. You should try and keep the factors objective rather than subjective. And if you're going to use things like attendance as a criteria for selection, do be aware that that could discriminate against disabled employees. And for disabled employees, you should disregard any absence that arises from their disability. So if you've got an employee who's disabled with a back problem who takes 2 weeks a year off work because of that back problem, you should disregard those 2 weeks of absence for the purposes of selection criteria. Any other absence, if they were off for 2 weeks with flu, that doesn't arise out of their disability, and so it can count. But do be careful about about attendance criteria and illness criteria and the effect that that can have on disabled employees. You also need to inform the employees about their entitlements to notice pay and statutory redundancy pay. Notice pay will be their contractual notice pay or 1 week per year of service up to a maximum of 12 weeks, and there is no cap on that. Statutory redundancy pay, as a general rule of thumb, you need to look at paying 1 week of pay for each year of service that occurs below the age of 41 and 1.5 weeks for each year of service that occurs above the age of 41. And the statutory redundancy payment is capped currently at £525 a week. So the maximum statutory redundancy payment available to an employee, only 20 years of service can count as well. So the maximum statutory payment is currently in the region of £17,000. And there is a very helpful calculator on the .gov website. If you just search statutory redundancy pay on the .gov website, it will give you a calculator where you simply put in the dates and your employees' pay, and it will calculate their redundancy for you. You also need to consult with them about if any alternative roles are available. So discuss any other vacancies that may be available into the business that the employee at risk of redundancy could move into rather than be made redundant. And if you think a role may not quite be suitable for the employee, but might be a solution to this problem, you also need to consider, do you want to offer that role on a trial period? So you don't have to, it doesn't have to be set in stone about offering an alternative role. You can, and there is a statutory provision that an employee can be offered a role on a trial period, and then if it doesn't work out, the redundancy would be effective at the end of that trial. And you also need to consult employees about if they have any proposals for avoiding the redundancy. And like I said at the beginning of this slide, keep an open mind about that. Sometimes employees do come up with realistic proposals to avoid the redundancy. After the first consultation, you shouldn't really give a view about the redundancy. Go away, think about what the employees had to say, give them the opportunity to take in what you've had to say to them. And you should then hold a final consultation meeting about a week later. And that should be held either to discuss any issues that came up in the first meeting, and then to communicate your decision about whether the redundancy will proceed or not, and whether the role is actually redundant. Like I said before, do consider trial periods for suitable alternative roles. And like I said before, they're entitled to notice pay and a statutory redundancy payment, and neither of those payments can be claimed from the furlough scheme. It is quite important to carry out a fair procedure and make sure you do carry out a fair procedure. There are a number of potential claims that an employee can bring if you fail to do it. The most common of which is unfair dismissal. So if you fail to tick all the boxes with your procedure, if you fail to do your best to avoid the redundancy, the employee potentially has a claim for unfair dismissal. In a claim for unfair dismissal, that is capped at the maximum of £86,000 or a year's wages, which is the higher the compensatory award. And that really, it is a compensatory award that they would receive. So they would receive payment for the amount of time that they are out of work up to that cap. There is a potential claim for a statutory redundancy payment. So for example, if an employee believed that they'd been dismissed for a conduct issue when in fact the real reason for the dismissal was there was no longer a need for their job, and employers sometimes do this in order to avoid making a statutory redundancy. So if you don't follow a redundancy procedure and try to use some other reason for dismissal, such as misconduct, then an employee does have the right to claim a statutory redundancy payment. An employee also has the right to claim statutory redundancy payment if it's not actually paid by the employer. And there is also a protective award for a failure to consult according to the statutory provision. So this only applies where you've got 20 or more employees who are proposed to be made redundant within a 3-month period. But if you fail to consult those in accordance with the statutory procedures, they can be awarded a protective award. And if there has been absolutely no effort at all to comply with the statutory procedure, that protective award will be 13 weeks pay. With regard to redundancy and insolvency, employees, if the business is in such a terrible position that simply there is no money to pay notice pay or holiday pay or a statutory redundancy payment, then employees do have a fallback position, which is that these payments can be paid from the National Insurance Fund. And if an insolvency practitioner comes in, they will usually give the employees details of how to apply to the Government Redundancy Payments Office for repayment of any of those payments that can't be made by the employer because of insolvency. So there is a fallback for protection for employees in that situation. That's the end of the redundancy piece. I just wanted to talk to you about 2 issues that came up yesterday that were quite interesting in relation to COVID. The first of which was that we had an inquiry, we had about, well, we had 2 inquiries about substantially the same issues. The first was, can I force my employees to be tested, to undergo a COVID test before they return to work? The context of this was now that the government will make available to employers with more than 50 employees asymptomatic testing. And they will actually, the client that we were dealing with was actually having a mobile testing unit come to visit their workplace because they had some problems with COVID transmission. And they were asking, can we force the employees to be tested? And the second inquiry we have is can we force employees to be vaccinated? So dealing with the testing issue, you can't force an employee to be tested. You can't frog march them into the test and force their mouth open and force the swab in, obviously. So what the question actually is can we require employees to be tested and take disciplinary action against them if they don't? And there is no clear answer to this question. There is no case law about this. It's a unique situation, and I suspect that by the time any cases do actually get through the tribunal in a year or 2's time, it will no longer be an issue. But the general opinion at the moment is you can require employees to be tested if it's reasonable for that requirement to be made. So it wouldn't be reasonable to require a home worker to be tested because obviously there's no transmission risk. But if you've got employees who perhaps are working in high-risk environments, in close contact with other employees, and the risks aren't being managed or can't be managed by social distancing or PPE, then yes, it may be reasonable to require them to get tested. And it may be reasonable to take disciplinary action against them if they don't. I think it would be a very, very brave employer in those circumstances who proceeded as far as dismissal. But the current opinion is yes, provided we can show it's reasonable, then we can require employees to be tested and potentially take disciplinary action if they don't. Vaccination is much the same, although vaccination obviously is a far more serious requirement, given it's a far more invasive procedure and you have to be injected. It potentially has side effects. And so if you require employees to be vaccinated, then you must also be aware of the risk that potentially if they do suffer side effects, then there may be perhaps a legal liability on you as well as the vaccine producer. But again, it's all down to reasonableness, and there is quite a lot in the news at the moment about vaccination and employees, and again, the general opinion is yes, perhaps you can require employees to be vaccinated if it's reasonable to do so because they work in a very high risk area and there is no other means of managing that risk. However, do be aware that the NHS are not requiring staff to be vaccinated, and they're perhaps the most frontline staff that there are in the UK at the moment. Although on the other hand, in certain roles, the NHS has traditionally required staff to be vaccinated. So certain lab staff, certain members of staff have always been vaccinated for hepatitis B, for example, and that has always been a requirement of their role. The difference we are now in is that staff would usually be, prospective employees would usually be required to show they've had that vaccination before the NHS would employ them, whereas now we've got a whole tranche of people in employment who we are now perhaps asking to be vaccinated, which is a slightly different position. So yes, it may be reasonable to require people to be tested and vaccinated, but only if you can show it's necessary and there's no other means of controlling the risks of COVID transmission. Okay, I think we've got 10 minutes left for any questions that you may have now. Rachel, are you going to mediate the questions?
Lisa's going to do it. Okay, so Lisa, I'm handing over to you.
Hi, just checking you can hear me. Yep, lovely. David, thank you. We have had some questions that have come in. So I'll start with those, and I've got one of my own as well. So the first one just relates back to what you were talking about in the beginning in terms of communicating furlough to employees. Can that be done by email?
Yes, absolutely. The requirement of the directions, the Treasury directions on furlough are that agreements must be in writing. The form that writing takes is not specified, but emails are perfectly fine. They're an agreement in writing, but obviously be aware that you do need to keep them for 5 years. So if you have any sort of automated deletion of old emails, do make sure they're filed somewhere safe.
And just related to that, so if you've done the initial letter or email, how formal does the rest of the communication need to be? So, for example, if you've agreed an initial period, but then it has to be extended or something has to be changed, is that a simple email?
I think so. I think in that situation, you can just send an email saying, you know, we're further to our, you're probably going to have a discussion with the employee. So just say further to the discussion, we're going to extend your furlough on the same terms. Your furlough will no longer end on date X, it will now end on date Y, but the terms will remain as communicated to you previously.
Okay, thank you. I'm just going to read this one out because I think I just want to make sure I get the question right, but I'll bring Jodie in if I don't have this right. So it's a question about holiday. Can I furlough 80% and top up holiday to 20%, equaling 100% for a week holiday?
Yes, you can. What you can't do is you can't pay employees the 80% you receive back from the furlough scheme for holiday. They are entitled to 100% of their pay for any holiday period. But you can claim furlough pay while they are on holiday. You shouldn't claim furlough pay simply because they're on holiday. So you can't furlough. So if an employee has been working normally for this period and then says, oh, I'm going to take 2 weeks holiday in February, you can't put them on furlough because they're taking holiday. That's not what the scheme is for. But if they are taking holiday when they are furloughed anyway, then yes, you can claim furlough for that period.
Okay, thank you. If there are any other questions about or follow-up questions about holiday and furlough, please do type them in because I've been hearing a bit of that as well. Right, so
just to say on this point, we're now getting to a point where some employees have been furloughed for quite some time. And employers do need to think now about managing holiday. The rules on holidays have been changed so that employees can carry over holiday from last year to this year. But you do need to think about now that employees might have racked up perhaps 7-8 weeks of holiday by the time they will come back to work. And you need to worry about the consequences that is going to have on the business. of employees who suddenly get to June or July of this year with 7 or 8 weeks of holiday in the bank that they all then have to take in the last 6 months of this year. As employers, you can request employees take holiday at certain times, and it might be time for you to start doing that and requesting that they do take some holiday while they are furloughed, which you will pay at 100%, because you are going to have to manage perhaps these stored up problems that are going to arise through holiday accruing and not being taken during furlough.
Okay, thank you. So next question. Are the redundancy provisions different for directors compared to those who are employees who are not directors?
Well, redundancy provisions will only apply to employees anyway. It's only employees who have the right to a redundancy payment. And of course, it's only employees who have the right for unfair dismissal. So I take it that Clive is talking about directors who are also employees of the company. And at which most directors are. Most directors have some pay PAYE. So yes, but yes, essentially, if a director is also an employee, then yes, the redundancy provisions do apply. You know, obviously, if a director is carrying out his own redundancy, it's very, very, very likely that he's not going to sue the company for unfair dismissal at the end of that, and so perhaps. You know, you don't perhaps need to be as formal about a redundancy procedure in circumstances where the director simply isn't going to sue his own company for an unfair dismissal.
Okay, thank you. Next question. Can you illustrate the interaction between a statutory redundancy payment and a total termination payment? So for example, if an employee is entitled to a statutory redundancy payment of 2,200 and the employer decides for whatever reason to top this up to 3,000, is the presumption that the £800 extra is 100% taxable?
No, the presumption is that it's not taxable. We're looking at sort of section 401 to section 403 of a TEPA here, Clive. I know that Clive will understand what that means. But basically what that says is that a termination payment of up to £30,000 can be made tax-free to an employee. So the fact that an employer decides to give a more generous redundancy payment than the statutory redundancy payment doesn't change its character. It's still a redundancy payment, and it still qualifies for tax exemption up to £30,000. What an employer can't do is try and divert a contractual payment, say holiday pay or notice pay. It can't try and classify that as an enhanced redundancy payment because those payments are taxable. But provided the additional, the enhanced redundancy pay is genuinely a payment in respect of redundancy and the employer is just being more generous, then it should qualify for the tax exemption.
Okay, I think I followed that. Thank you for putting that in layman's terms. So a question I had, and I'll just give people a few minutes for any follow-up questions, is I wonder, because we've heard this from a few people, if you could comment on 2P in relation to furlough and whether people can remain on furlough if they are 2P'd over.
Yeah, it's a little complicated, but the general principle is that provided an employee was eligible to be furloughed at the time of the transfer, then the new employer, the transferee, the person receiving the employees under 2P will also be able to take advantage of the furlough scheme. Okay.
Thank you. We just had another question in. Can a member of staff still work for a company if they are on furlough from another company? For example, can they have 2 jobs?
Yes, they can. So if they have 2 jobs, they can be furloughed from one job and still receive and still be paid in another job. What they can't do is perform any services for the employer who is furloughing them. So you cannot, for example, and there is anecdotal evidence that this is happening, and I have come across it myself, is that employers are furloughing people and then asking them to come in and do a certain amount of what they call voluntary work. And that is unlawful. So you can't ask staff to do anything which would provide services to the employer or create any sort of profit for the employer while they are furloughed. But they can, if they already have another job, they can continue to work in that job, and indeed they are allowed to go and find alternative work with another employer, provided their contract of employment doesn't prevent that.
Okay, thank you. That's all incredibly helpful, and of course, it's a challenging thing to talk about, because we knew that that more of this was going to come in the first quarter of this year. But as we are hearing about all the redundancies, it's certainly, it's hard to hear about, but it is something we need to face. And if it's something we have to deal with, then we want to do it well. So thank you very much for this session today. We are almost to 10:30, but I'm just going to have a little look. And we don't have any more questions, but of course, if you have any follow-up questions, please do be in touch, whether it's about HR and employment or about anything else related to the grants or recovery, anything that we can help with. And just a final thing from me, this session has been made possible today. The training sessions we're running now and have been running since July. We've done in partnership with the Reopening the High Street Safely Fund and project, that's RHSS. It's an EU funded project, and the money goes through Canterbury City Council. We, as the Business Improvement District, are running that for Canterbury, and there's also a team working in Whitstable, Tankerton and Herne Bay. And that means that we can provide these sessions for businesses across the district. And of course, the connection that we have and collaboration we have had together over the year has been enormously helpful. So I can see, just looking at the list, that we do have a great mix of businesses from across the district, and also Debbie from the RHSS team as well. So again, thank you, David, very much for joining us today and for that really helpful presentation. And we look forward to seeing you all on a session soon. Take care.
Bye-bye.
Bye-bye.